Good afternoon. This is Craig Cook, and I'm speaking to you from the law offices of Craig L. Cook. And I want to talk to you about the difference between divorce mediation versus divorce litigation. That's kind of a misnomer, or not necessarily misleading, but kind of can be confusing. And what I mean by that is this. Divorce is litigation. In other words, you have litigation and divorce. And what you're talking about when you're talking about mediation versus litigation is how do you get that particular divorce case resolved? So if you let the judge decide it, you can technically call it divorce litigation. So as I've written here, divorce litigation is where you allow the judge to make the decision concerning custody, if minor kids, and property division. So that's where you don't have anybody come in and try to help you settle the case. You have to live with what the judge decides in your case. A lot of times you have little to no control here and everybody gets mad, their nerves get stepped on. It's not a good event. If you can help it, you don't want to completely stay in this particular lane. Sometimes you have to because you just have something that you cannot get past, but you need to, if you can try, you need to do the type of mediation. Divorce mediation is where the parties come to an agreement regarding the custody and property division. Now this will only work if both sides are willing to give a little. If both sides are not willing to give anything, or one side wants everything, the other side is not going to get anything, that's not going to work. So everybody's got to give a little bit. Most of the time on divorce mediation, in regards to custody of the kids, the prevailing thing now is the parties should have joint custody. You know, that's one party is just unfit parent. Also in regards to divorce mediation, you can control what's going to occur. In other words, a lot of times people have different interests or goals in getting a divorce completed. One party may get more than what they would have gotten if it went before a judge because the other party just simply wants to get it done and move on with their life. So the preferred method is to go to divorce mediation. Now I want to talk to you a little bit more in detail about the cons of divorce litigation. I've already touched upon this. One of the cons is that you are not controlling how things are divided. Judge makes that decision. You have no control. Once he says, I'm going to make that decision, it's done. Now, of course, you can appeal it and file motions and ask it to be reconsidered, but most of the time that doesn't work. The pros, specific pros to divorce litigation, that you do not have to make those decisions. In other words, if you don't want to be the one making the decision that the judge may have to make in regards to not being joint custody, but just you simply having custody, and so the child doesn't go to see the mother or the father as much as if there'd otherwise been another agreement, then the judge makes that decision and you can't be blamed for that decision necessarily. If you can't make a decision or your mind up on how you divide stuff and you just want somebody else to do it for you, let the judge do it. I personally would not advise that. I would want, because you don't know what the judge is going to do. You might have 10 different cases, 10 cases with the same or similar facts, and you may have 10 different decisions. It just depends upon the credibility of witnesses, the value, etc. I mean, there's just a lot of things that goes into that. The cons of divorce mediation is that you must give some to get it resolved. You don't get everything you want. You have to come to an agreement. You have to negotiate. You have to try to get along with the person with whom you're trying to get divorced from, and the reason you're getting divorced from them is because you can get along with them. It's kind of oxymoronic, but that's the way it is. So you got to negotiate how to get back out of this bad relationship or bad deal. Then the pros to divorce mediation is that you control how it is resolved to a certain extent. So you're the one that decides what you're going to give up, and you're the one that decides what you're not going to give up. And if you can go through that process and get to the end of that process, you have a control of how your divorce is coming about and how it's getting concluded. Deciding between the two would be if the other party is the one that is responsible, then divorce mediation is the way to go, like I talked about before. But if the other party is not responsible, then let the judge take care of them, or take care of the case. And what I mean by that is, I talked about this just a minute ago, you got two other kinds of other parties that you're not going to be able to get something done on. One of them is going to be the party that's not going to give anything. They're a responsible person, but they're not going to give anything. The other kind of party is the person that's never going to get anything done, they're never going to do anything, they're never going to complete anything, they're never going to do anything they promised to do. So you need to go ahead and just have the judge order them to do it, and then when they don't do it, you can come back in and file a petition for contempt. Preferably don't do this. If you can help it at all, what you can do is, if you do come to an agreement through the mediation process, and they don't do what they're supposed to do, or per their order that they entered into, or the agreement they entered into, you can always come back and file a petition for contempt. If you have any domestic relations issue, divorce, child custody, paternity case, contact us at the law offices of Craig L. Cook by calling us at 479-783-8000, contacting us through our website, lawofficesofcraiglcook.com, or you can email me directly, Craig at lawofficesofcraiglcook.com. Thank you.